Well, welcome to Passage to Profit,
The Inventor's Show.
where we're all about intellectual property and new businesses and the challenges that they bring.
That's right. And if you have a trademark, copyright, patent that you need help with, or you just want general intellectual property advice, or somebody's threatening to sue you because you're infringing or whatever, this is the guy.
Absolutely. I have no shame when it comes to that. And by the way, Mr. Cuomo, Governor Murphy, if you're listening out there,
I'm sure they are.
I need a haircut, and I will absolutely agree to stay in quarantine an extra month if you can just get me to a barber, because this is driving me crazy, okay? So please, please, please help us out here. But if you're not Governor Murphy, if you're not Governor Cuomo, or even if you are, and you have an intellectual property project or an entrepreneurial project, you're in the right place, because Passage to Profit is all about entrepreneurs and entrepreneurism. And today we're going to do things a little bit differently. We're in quarantine, so this is the first quarantine show that we've done in a while. And Elizabeth and I are here at the office at Gerhardt Law, but our employees are safely at home. We feel that this is like the right level of social distancing, don't you? Actually, we could get even a little closer.
I think we're fine.
Okay.
So we're going to start with IP in the news. And hallelujah, everybody. The USPTO has ruled that artificial intelligence cannot be named as an inventor on a patent. Yay!
What about artificial unintelligence?
Well, yeah. But seriously, there was an article on TheVerge.com by John Porter, and Europe had already decided this.
Right.
So people are asking, why would somebody want artificial intelligence to be an inventor on a patent? That's, kind of weird. There is a society. They are called the Artificial Inventor Project.
And let me guess, they are wanting artificial intelligence projects and creations to be patentable.
They do. And their reasoning is, what if a whole bunch of people work on something and they feed a bunch of data into the computer and the program comes up with this amazing invention? Can it be patented? What if there's thousands of inventors? Are all thousands of those people who fed code in or did whatever, are they all inventors? So couldn't the artificial intelligence be the inventor and cover all those people?
I think that's like one of the most ridiculous things I've ever heard of. I think if you want to let computers get patents, then you should just change the rules so that computers can get patents, right? I think that's the way to approach that. The bigger question is do you want computers to get patents? I get all scary because I think of like Skynet, right? Patenting everything. And then we're all just like living in our little cubicles and whatnot. And because these computers just keep cranking out these patents and they own everything.
You are safe for now. so let's move on to our next topic.
All right.
Which is yours.
Oh, my topic. Yes, it's Google versus Oracle, and that's another software issue. And so it's one of these disputes that's been going on for a long time. It's up at the Supreme Court level now. And it's all about whether certain types of software is copyrightable. For example, APIs, which are like these little snippets of computer program that, like for Google Maps, if somebody's writing a program, they want to put a Google Maps icon in the website, they just put this app API in there and it shows up. And then if you want to have a shopping cart, that's like another snippet of program code that they just put into the website. And then people, Oracle developed all of these things. They put it out there for free for everybody to use. Google started using it. Oracle changed its mind when they couldn't reach a deal, and then there was a big lawsuit on it.
Well, I think actually what happened was it was Sun Microsystems, and then Oracle bought them.
Oh, okay. So
when they developed
Oracle
Java,
now?
It's Oracle now. So I think maybe Sun Microsystems, I don't know for sure. I don't know the history. Maybe they were a little more generous than Oracle. I don't know. But then Google's made a lot of money off these. So
I know it was they offered $40 million to get this resolved. And this was like 7 or 8 years ago. That's a lot of money 7 or 8 years ago.
Right.
For something that was originally in the public domain. But it is now before the Supreme Court, and they're going to decide this. And I guess if you're a computer programmer programming APIs, it's a big issue, but it's also a big issue about how keeping everything open makes it standardized, and if you standardize things, then software development can happen a lot more quickly. So
And it's a lot easier.
a big issue and one to watch. So we'll let you know what happens if the Supreme Court ever goes back in session.
Right. So they actually Google brought up two things. One, API should not be copyrightable because they're not just an expression of your whatever, which is what copyrights are, but it's actually a utility because it's an interface. So it shouldn't even get a copyright to begin with. But if it does get a copyright, then they can use it under fair use standards, which
yeah, fair use that's usually non-commercial use. So if you want to use an article in a classroom, then you're not infringing that copyright because that's considered fair use. And so somehow, some way, Google is trying to make this contorted fair use argument, which makes no sense because this is like totally commercial and it's not anywhere close to the law. So if they win, it's going to be on that issue, it's going to be because the Supreme Court changes the law. So has a lot of ramifications for software coding going forward, what people can do, what they can't do. And I hope that the Supreme Court finds against Google and finds for Oracle. I just think that's the way it should go. But they won't listen to me, so we'll see what they have to say.